Okay, so what about defenses to negligence? Now, one of my favorites is assumption of the risk. And the requirement for this defense, you've got to have knowledge of the risk and voluntary assumption of the risk. Now, it can be done by express agreement or implied, so implied into the facts. And the way I like to use this is, let's say you go see a baseball game. All right, you're sitting on the third base line, and you get hit in the head by a line drive foul ball. Did you assume the risk? Well, baseball is America's national pastime. Isn't it common knowledge that a line drive foul ball could go down the third base side? Well, sure. Why else do you think all those little kids have the gloves on? So, in all likelihood, a good defense to negligence for a baseball stadium would be that you assumed the risk when you went to the stadium, knowing that there was the possibility that you could get hit by a foul ball. And you can certainly make up all sorts of defenses to that defense. Oh, you don't know anything about baseball, you're from a foreign country that doesn't have baseball, and certainly you can try that. But again, that's why we have lawyers. Superseding cause. An unforeseeable intervening event may break the causal connection between the wrongful act and the injury of another. So certainly if, you were, I think the example the book uses, you're riding your bicycle and I cause you to trip on your bike. So you fall, you get hurt, you're sitting on the side of the road, and then an airplane comes along and crashes and you die. That's probably a superseding cause. All right, that's not foreseeable. Contributory and comparative negligence. Now, the book goes into a lot of detail on this, but let's just think about it. Contribute. All right, if you contribute to the negligence, then you're barred. But comparative negligence is compared by the two, you reduce your amount based on that. Okay, that's the bottom line. But this also goes down to what type of rule does your state hold. Now, I know in Georgia we have a comparative negligence statute, so even if you're just a little bit negligent, you can still recover. Special negligent doctrines and statutes. Res ipsa loquitur, I can't ever say the couture word, but res ipsa, the fact speaks for itself. Applied only in the event of creating the damage or injury is one that ordinarily does not occur in the absence of negligence. And there's a case on this, the shoebox case. A guy walks into the shoe store and a bunch of shoes fall on his head. Well, there's no one around. There's nothing going on. There's not an earthquake. There's no whatever. And the court applied res ipsa in this case, because the only way those shoes would have fallen was if someone had stacked them negligently. Okay? So that's res ipsa. The thing speaks for itself. Negligence per se may occur if the individual violates a statute or ordinance providing for a criminal penalty, and that violation causes another to be injured. So if you are, violating some criminal statute and it causes harm to someone else, you are most likely going to be negligent per se. Danger invites rescue. A person who is injured while going to someone's rescue can sue the person who caused the dangerous situation. So if Leonardo and Buzz-Off, get into a fight, all right, and Leonardo gets hurt, He-Man comes to the rescue and tries to save Leonardo. Well, He-Man could sue Buzz-Off for hurting Leonardo if he was injured. Okay? Special negligence statute, Good Samaritan. Someone who is aided voluntarily by another cannot turn around and sue the Good Samaritan for negligence. This is designed mostly to protect doctors and nurses and that sort of thing. Also, the Dram Shop Act. For those of you that are over the age of 21, you may have had an alcoholic beverage from time to time. It could be that if you get intoxicated and the bar continues to serve you and you subsequently harm someone, that person that is harmed could turn around and sue the bar for being negligent for serving you, even though you were intoxicated. It doesn't mean that you're not going to get sued either, though. Cyber torts. Now, this obviously is, for the most part, fairly new, but the first thing you got to do is, when we talk about cyber torts and defamation online, who was the author of the defamation? Who made the statement? Now, you go on Facebook, it's pretty easy, but who's going to be liable for that? Well, probably the person that made the post. But in all actuality, what about the ISP? If you're connected with, AT&T or Comcast or something, could AT&T or Comcast be liable for you making a post on Facebook saying something dirty about someone else? Well, believe it or not, case law and statutes have come down on this, and they have held that ISPs are not a publisher. Spread of spam, we see this all the time. I know about every morning I wake up, I check my email, and in my junk mail I have 25 or 30 spam messages. Now, you're not supposed to get those, but how do you enforce it? So a lot of stuff here. Biggest and most important part of this chapter is the negligence information. Remember, duty, breach of duty, causation, and damages. You got to have all four to have negligence.